As I said, my lord, it's not a case of Honorable Governor and the Honorable Chief Minister. This would apply to all public servants under the Prevention of Corruption Act. In many cases,
So if I can, so the suggestion is, if natural justice is to prevail prior to 17A, and you're paraphrasing 17A to 154, then before registration of FIR, notice will have to be given heard.
exactly.
That will
My
have-
learned friend, in
it would
fact,
be-
cited, my learned friend, in fact,
That is what you're
cited
trying to.
Rajesh
Yes.
Agarwal judgment,
Yes. that's right.
where he said that he had an honor to assist the Honorable Court. I incidentally also had an honor to assist the Honorable Court, where my learned friend inadvertently missed that part where the Honorable Court said that in criminal matters, hearing is not required in that very judgment. Otherwise, my lord, kindly see the
Otherwise,
consequence.
prior to 154(1), every accused will have to be heard. Now, of course, in the new BNS under 218 and it's pre-cognizant stage, yes, a notice is required.
No, even there, the Supreme Court says not required.
Yes.
Perhaps my learned friend was on VC, it missed out. I said the argument was that to declare account fraud is like an FIR. So how can you hear before an FIR? The court made the distinction that no hearing is required before FIR. But to declare an account fraud, which is akin to criminal, you must have a hearing. That is the distinction I made. Perhaps you missed it on the VC.
Lord,
Yes,
kindly, my lord, consider if my learned friend is right that before granting approval under 17A, a hearing is required. 17A is for the prevention of corruption offences. It applies over the board
Yes.
to every public servant.
Yes.
The moment, my lord, notice is given, there are all possibilities, my lord, that the evidence will be lost. That is one more reason, my lord, not to read hearing or principles of natural justice under 17A. Suppose, my lord, a collector were to give approval for the deputy collector's corruption case, and he is in office. He might, my lord, tamper with the evidence. He might misplace the file. The evidence will go. This is one more reason why 154 or 17A, no hearing.
Except the preliminary inquiry that is in 120.1 of Lalita Kumari.
Yes, my lord. In a given case, in Lalita Kumari says, my lord, that if it is something, lord, suppose I go and file a FIR which is completely absurd, that Mr. So-and-so I approached and he demanded 50,000 rupees. Then straightway don't register an FIR and pick him up. Conduct a kind of a preliminary inquiry because it's the station house officer who does this.
Yes.
While here in 17A, why that preliminary inquiry? Only contemplation is whether you find cognizable offence being made out from the material on record. So merely because the Honorable Governor thought it fit to issue notice in one case does not necessarily mean that non-issuance of notice in other two cases
Initiate the proceeding.
would vitiate the order. Now, my lord, I am relying upon at page 14, my lord's, my lord, very illuminating judgment, my lord, in Dr. Ashok versus the state, where your lordships were pleased to
Yes.
lord, distinguish.
17.
And I think this is the first judgment, my lord,
Yes.
juxtaposing 17A and 19, my lord.
Yes.
And, Lord, your lordships were based upon that judgment, my lord. There is a direction also issued, my lord, by the
High Court.
High Court, my lord,
Yes.
that even it applies to the magistrates. The magistrate also cannot straightway issue process or call upon the complainant to be in the witness box, etc. The complainant will have to go with 17A. So, my lord, I'm not reading, my lord,
Yes,
Dr.
yes.
Ashok, my lord, it is your lordship. How there is an application of mine.
Huh.
My lord, kindly have, my lord, the original file. I'll share it with my learned friend, Mr. Singhvi, and one more copy. You have copies? Okay. And the learned advocate general also, my lord, by virtue of his office, though he is not concerned with the list between, my lord, the Honorable